Sure.
So this is the first in a series of talks about openness in science and discussing topics ranging from open publishing to standards and licensing. And today, and this series of talks is hosted by OpenWetWare, which is a wiki for biologists and biological engineers. Go to it, openwetware.org. Today, we're really excited to have John Wilbanks here. John is the executive director of the Science Commons, which is located here at MIT. And it's a project of the Creative Commons, which probably most of you have heard about. So, and John will play along. John is a really great person to have here because he has been at the intersection of policy, law, and science, especially biology, for almost a really long time.
It's not long enough to get a PhD, so don't take it too seriously.
So before coming to the Science Commons, John was at the W3C, the World Wide Web Consortium, and starting up the Life Sciences division of the Semantic Web for Life Sciences. And before that, he founded and led the acquisition of a company called Celico, which worked on semantic web networks, I think, or semantic, for biological information for pharmaceutical industries. Prior to that, he was the first assistant director to the Berkman Center for Internet and Society, and there were a lot of great people there at that time, I think, including Larry Lessig and etc. And finally, before that, he was a legislative aide to Congressman Pete Stark from California. So has a wide variety of experiences, and it lets him talk about all these things in a very lucid way. So we're really excited to hear you talk again.
Thank you, Shri. I know less about science than most of you that are scientists. I know less about technology than most of you that are technologists. So if I make mistakes, feel free to raise your hand and call me on them. What I try to talk about is how these things come together. And I'd also like to thank everyone for coming on a Friday afternoon before spring break. I probably wouldn't be here if I were you, but I appreciate it anyway. So Shri asked me to come and talk about openness in science, and I have a very distinct perspective on openness in science, which is that reuse is the key element of openness in science, that looking for reuse is the most important thing we can do because reuse is the measure of the impact of science, whether it's technology, software, biological research. Innovation is related directly to the rights and freedoms to reuse and transform knowledge, whether that's a journal article, whether that's a piece of DNA, whether that's a piece of computer software. It's having the right to transform and reuse that in a creative way that really drives innovation. One of the arguments I'm going to make is that law, economics, and technology are actually not making this easier, they're making it harder. Bless you. And that we may have some experience from free software and free culture that can guide us as we try to figure out how this works. So this is the British £2 coin. It came out in 1997. It's got some DNA on it. DNA is an interesting concept around reuse because Watson and Crick reused the work of a woman named Rosalind Franklin to decode the double helix structure of DNA. They did not give her an awful lot of attribution for reusing her work. She may have been one of the most screwed over scientists of the last century as a result of this. But on the side of the coin, which I find very ironic, is inscribed the phrase "standing on the shoulders of giants," which is a cheesy, classic thing that Newton said in a letter to Robert Hooke when he was talking about his classic work on gravity. That is used by scientists and philosophers of science to talk about sharing in science, even though it was actually an insult because Robert Hooke was a very short man. It's still become a cheesy classic phrase for sharing in science. So just to kind of set the tone. I've found it useful to start with a brief introduction to copyrights and patents. Most people don't actually know, in a sense, what copyrights and patents actually are. There's a joke inside Creative Commons that if you work there long enough, you become a de facto copyright attorney. So this is a letter that Thomas Jefferson wrote on August 13th, 1813, where he laid out his philosophy that went into the Constitution on intellectual property, and I'll kind of talk about what that means. There's a key phrase here. I won't make you try to read his handwriting. It says, "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper or candle at mine receives light without darkening me. So this is what makes intellectual property different than physical property. And when Richard Stallman talks about free as in speech, not as in beer, what it means is if I have a beer and I give it to you, I don't have a beer anymore. But if I have an idea and I give it to you, we both have the idea. If I have an MP3 of a song and I give you a copy, I don't lose my copy of the song. Intellectual property is different than physical property because of this. And so the Constitution, the framers of the Constitution, created a set of government-sanctioned monopolies on things like expression of ideas, inventions. And the idea was that they would have a limited time. And these are valid, these are relevant in the scientific sense in that if you write a journal article, or if you give a conference presentation, if you write a memo, if you write software, copyright's attached to that. Kind of magically, the minute you pull your pen off the paper, you have this government monopoly that you can use. Patents apply to things like genes, proteins, machines, technologies, unfortunately also to software. And contracts, which create sort of one-on-one property rights, not intellectual property rights, can apply to anything where two people will sign a contract. So without realizing it, copyrights, patents, contracts, they're everywhere. If you write a journal article, copyright. If you work on the Huntington's disease gene in the context of a pathway, Mass General Hospital owns the patent on that. They're everywhere. You just don't necessarily notice them around here. And then I always like to show the platypus. There's a kind of intellectual property right called sui generis. It means at the top of its own genus, or the only of its own genus. So a platypus is a sui generis animal. The European Union has actually created a sui generis database intellectual property right. It's an artificial, brand new property right that protects databases and databases alone. It doesn't really work that well according to the empirical evidence out there, but maybe that's why we are contemplating one here in the United States. We'll find out. Just one brief other comment on databases and property rights. In the UK, there's a different kind of copyright on databases, and it's called the Crown copyright. So the Crown did this massive ordnance survey of all of the land in England. You have to get explicit reuse permissions and licenses from the UK government to do that, which is why there is no Google Maps that came out of the UK. The open data that the United States created through satellite surveys is actually used over the data that was created in the UK because our data has no restrictions on reuse. And so if you look at a Google map of London, if you look at any satellite surveys that any entrepreneur uses of the UK, they're using American data and not UK data. So here's a place, here's kind of an existence proof where creating an intellectual property right hasn't really helped innovation or reuse. So that's just kind of setting the tone. Copyrights provide protection on expression. So it doesn't protect the idea that X phosphorylates Y. It protects the paper in which you lay out that idea and prove that idea. Patents protect the invention. So if you actually do something with that phosphorylation, patents let you protect that. And in particular, that lets you prevent someone else from doing it. Patents don't give you the right to do something. They give you the right to exclude someone else from doing it. So for example, if you're dealing with a patented gene, and I own the patent, I can prevent you legally from actually synthesizing that gene because that's making the invention. I can prevent you from mailing that synthesized gene around because that's practicing the invention. Now, there's been 3 long scientific traditions in the United States that make these rights not impinge on scientists, especially academic scientists. And the first is there's no protection on raw facts. And so the kind of classic thing that we say is that you can patent the mousetrap, you can't patent the data that established the tensile strength of the steel in the mousetrap. A second is that government-funded works fell into the public domain traditionally. And last is something that's called the Mertonian tradition. This is a guy named Robert Merton. I alluded to Standing on the Shoulders of Giants. He wrote a long book of sociology on the origins of that phrase, which is where I got my joke from. He's also written extensively about the sociology of publications and citations in science. There's a link to some of his papers, which I would highly encourage you to follow if you're into this kind of thing. And the Mertonian tradition basically said that at a university, in particular, if you publish and you refer to a data set, you need to publish the data set too, right? Now, all 3 of these traditions are under attack for a variety of reasons. The first is copyright transfer from people like you or your PIs to journals. And I'm going to talk about that and the impact that has in a minute. But basically, when you transfer your copyrights to a journal, they can use that monopoly right to create contracts that prevent reuse of the information. Second, and I'm not going to go into too much detail on this, about 25, 30 years ago, the US Congress passed a law called the Bayh-Dole Act. The Bayh-Dole Act, it's, Bob Dole, if you remember from the campaign in 1996, they said, we're putting all this money into scientific research. We don't have any way of knowing whether or not it's being commercialized or monetized. There's no incentive to the universities to do that. So there's now a mandate legislatively that if you can commercialize something, that you should do so. And this was intended for all of the best purposes, and it's actually had a lot of really beneficial impacts in terms of getting pharmaceutical inventions to the market and that type of thing. But it's created a default setting of first patent, then share, or first sell and then share. And that default setting is kind of skewed because most scientific inventions don't have lots of money coming out of them. But everything now is encouraged to be locked up. Mapped to that, judicial changes. You can, in fact, come very close to patenting a raw fact. Some of the gene patents that came out in the late 90s and that have been coming out are very close to patents on facts of nature. Because I can prevent you from synthesizing a gene which exists in all of our genomes because I identified the function of that gene. That's pretty close to patenting a fact. And then last, anyone who's ever dealt with a database or a piece of software on the web has dealt with a click-wrap contract. Now, if you deal with enough click-wrap contracts, you can get this web of rights that basically says you can't do anything with these 6 databases. You can't integrate them, you can't put them together, you can't republish them, you can't build an index to them, because each of them has a different right that's attached to them. So these 4 elements are what Jamie Boyle, who's one of the lawyers that's on my board, calls the enclosure movement. And so an analogy back to the physical property world, in England, there used to be a lot of common space. And then the concept of property was basically created when you put up enclosures. You put up fences, and you fenced in the commons. And he calls this the second enclosure movement. But the difference is we're doing this on intellectual property, which is shareable, which is digital, which is non-rivalrous. Again, we can both have the idea. So back to the point, reuse may be the key to scientific innovation, but the law isn't making it any easier right now. And in fact, as the law moves onto the web and into the networks with things like digital rights management, the combination of law and technology actually makes this harder. But we can actually look to software and to culture for some inspiration and how we can actually use the law to make reuse easier. And so I call this copyright Aikido, right? So Aikido is a martial art in which you use the energy of your opponent against your opponent. You don't practice strength. And I think the GPL, which I'm going to talk about in a second, which is the GNU General Public License. It was invented by a guy named Richard Stallman. He lives in Project Mac on the same hallway I do. Basically took this power of strong copyright and flipped it over against the traditional uses of copyright and said, I'm going to use this monopoly right as a lever to make things more open, not less. Right, so copyright's got all this weird stuff. Copyright lasts 75 years after you die, mainly because otherwise Mickey Mouse would be in the public domain. There's a host of other reasons, including Casablanca is still making money for the studio that made it, even though everyone that made it is dead, because the copyright still hasn't expired. So because of the entertainment industry and some other areas, software code copyrights also last 75 years. So Microsoft, for example, won't lose copyrights on its basic works until about 2055. That's how long the monopoly right exists. So it's this incredibly powerful thing. And my boss, Larry Lessig, actually went all the way to the Supreme Court trying to prove that this was an unconstitutional thing to have copyrights last this long. Going back to the Jeffersonian note, copyright should be a limited term monopoly. But it's not. So Richard Stallman had the idea to flip it and say, well, if it's this powerful monopoly right that it's being abused, we can actually use that as a lever to make things open. And that's the GNU up there on the right. So the main thing here is attribution, so I wanted to make sure I gave Marcus attribution. So this is the GPL, right? The General Public License. And you don't have to read it in detail. The primary elements here are that I give you the right to the software code that I write under copyright. And you can do whatever you want to it. You can look at the source code. You can rewrite it. You can redesign it. You can do anything you want with it. You can integrate it with code that you wrote yourself. But the minute you give it to someone else or put it on the web or distribute it in any way, you have to reuse the same license. So the license passes through to your work from my work. So this is a use of copyright that says, I'm going to give you something really useful, but the monopoly right's going to force you to make whatever you make open. And I would argue that this license has changed the world. When this license was written, there was no such thing as free or open source software. And now there is a vibrant, massive free and open source software community, I would argue, directly as a result of this license. Now, I work for Creative Commons. We're a nonprofit organization, and we were inspired by the free software movement. Now, the free software license I just showed you is exclusively intended for computer source code. It talks about releasing source code. It's not really written for songs or for pictures or for web pages or for blogs or for literature. Our licenses are explicitly designed for those things. You should never use one of our licenses for software. You should use the GPL for software. But what we do is basically create a modular series of licenses based on the same concept. We grant everyone the right to distribute, display, perform, webcast a work. And so a work is a picture, a song, a web page, a piece of literature. But you can apply conditions. You can apply leverage to the granting of the monopoly right. You can require no derivative works. You can't change my work. You can allow or disallow commercial use of it, and you can make it viral. We have a license that's basically the GPL for music. It's basically the GPL for pictures. Now, there are a few things, and so just so everyone knows, Richard and others in the free software community have distinct problems with a couple of these licenses as being non-free. In particular, the no derivative works license. I'm not going to get into that debate. That's a philosophical debate, which we can talk about afterwards. I wanted to talk about some of the things that we've done differently at a structural level than the Free Software Foundation that I think have been responsible for some of the takeoff of the licenses that I think are instructive for sharing and reuse in the sciences. And the first is to make the policy clear to all copyright holders. So we go back. This is the GPL, right? This is a lawyer-readable tool. Right? I've been doing copyright stuff, and I'm not an attorney for about 18 months. I still hate reading these things. Right? It's miserable. It's worse than software documentation. So we make our licenses clear to humans. Right? So we call this the human readable license. You are free to copy, distribute, display, and perform, make derivative works, make commercial use, as long as you give attribution. Right? This is written for normal people, not lawyers. So this is the legal, the lawyer-readable version of it. And so you see it's got all these definitions and disclaimers and all the things that lawyers get paid to draft and write. What we did was make this iteration of the code portable into other languages and other legal systems. So this has at this point been ported into 27 distinct countries, legal systems, and languages, which means if you upload a song in Brazil, you can download it in the United States under the same license. They interoperate in a software context. And this is, I think, the second thing. So you make it human readable, make the code portable, make it machinable. Right? Use standards to make the license policies machinable. So this is using semantic web language called RDF, and it describes that license that I just showed you in a way that a machine can understand it. So if you look at just the first word on the left and the last word on the right, you can see the permissions and the requirements. So this license allows reproduction, permits commercial use, right? It permits pretty much everything, and it just requires notice and attribution. And so the idea behind this was, okay, well, if we do that, if we make some definitions of what these things mean, so this is another way, you have to refer to something machine readable, and that's what we've got here. What does it mean to give permission? What does it mean to distribute? But the idea behind all of this was basically to hide the complexity of this from the user. So you could actually select a copyright license by answering 2 questions on a web page. That was the reason for designing the machine readable version of this, was make it really easy for a human to choose this. So do you want to allow commercial use? Do you want to allow derivative works? If you do you want to make other people share alike? Right, that's why we did this. Now, I was talking about reuse. Right, so what we've found is that by making it open, making it standard, reuse became something pretty cool and easy. So suddenly we had some people say, well, you know what, we could build a search engine. We could put that into Firefox, and you could restrict your search for music to songs that you were allowed to remix. You would never be in danger of violation. So that lets you leverage the existing web and software infrastructure, again, for reuse, because you use standards, because you're open. So people like Yahoo can come along and say, well, search only for Creative Commons licensed content. Right? It's easy to do when you're open and you're standard. And then you start to get really cool unintended consequences. So one of our users wrote a content management system that lets you track the genealogy of remixed songs. So you can say, show me how far my song propagated into the remix culture by tracking using the machine-readable data. We didn't design this. This was stuff that people came along behind us and figured out really cool things to do with. And what you can actually do now is take open policy metadata and use it as a way to track the impact of a copyrighted work. If you come up with a really cool drum loop, people are going to reuse it more often than one that stinks. And here's a free, quick, single-click way to see that. So again, back to the point. Copyright can work in favor of reuse if you do it right. Reuse leads to creativity that the authors didn't even think about or envision. And technology lets us start to actually track that in a way that's really easy. And to kind of bring this home to science, right now the only trackable way to do impact that we have really is patent licenses and citation indices. And I don't think that those are very accurate, granular, or dimensional ways to look at the impact of your work in a realistic manner. So that's the background. I promised Shri I would give case studies. So I'm going to start with trying to do text mining on biological literature to look for interactions and relationships and really focusing on the impact of copyright transfer on that. So there's a lot of data in science. These are kind of slides for people who aren't scientists. There's a lot of data in science. It's increasing rapidly. There's a lot of literature in science. It's increasing rapidly. So you can go, 244 million searches in 2000, 677 million in 2004. It keeps going up. And it's really hard for any one person to store and leverage all the knowledge and information. So there's this thing called semantic web, where we take the existing web and we give it some machinability. In the same way we took that license for Creative Commons and we made it machinable, we can take some of the basic ideas of science and make those machinable. And this would be great. But the problem is that the web just needed technical interconnections. If you and I had fiber between us, we could use HTML, HTTP, and URLs, and our websites would link up and we could hyperlink them. But on the semantic web, you need some knowledge interconnection. You need to know how a gene relates to a protein, relates to a function within the cell, relates to a tissue, relates to a compound. And most of that information is proprietary. It's been transferred by scientists to journals or to database providers based on copyright. Right? Elsevier encrypts the clickstream, so I can't even see what URLs you click on for Elsevier articles to find out what articles you read. Right? It's more encrypted than like iTunes, just to do basic analysis. So I can't do what Amazon does. I can't even see what you're browsing. If I'm your librarian here at MIT, I don't even know what you're reading. I'm not legally allowed to as a result of copyright transfer. This is kind of what it looks like. So the funders of research give monies to the scientists, right? All of you who've ever gotten a grant know that some of that money never goes to you. It goes to the university to go to places like your library. So the library gives you free access, right? If you're here at MIT, you don't ever see that screen that says this article will cost you $40. But trust me, anyone that's outside sees it all the time. You give your copyrights to the journals because by getting those publications in Nature and Science and PNAS and Cell, you get grants, you get tenure, you get advancement. You have incentives to give up your copyrights. And the journals make money, whether that's for their stockholders, for their professional societies. This is a system that's grown up over time. It made an enormous amount of sense in the pre-web days. And so there's a guy at the Wellcome Trust who gave me this graph. The Wellcome Trust has actually become the first organization to mandate that scientists don't give their copyrights away. If you get money from the Wellcome Trust, you don't get to play in this game anymore. So the nice thing is that there's still enough to get started for this whole semantic web stuff anyway. So there's this movement called open access, which has erupted, which I'm not going to get into in detail, which basically uses Creative Commons licenses to manage the copyright transfer. They give away the articles on the day of publication. There's a lot of author self-archived literature. Here at MIT, there's a repository called DSpace where you can put your articles if you retain the rights to do so. And there's a lot of community resources of text, like basically the abstract for any biomedical literature that's ever been written is at PubMed. So there's enough to start. There's also a lot of public databases, data models, there's some private companies that have seen the light and are willing to play in this. So what Science Commons is actually doing, we just started this project in January, is going to the neuroscience literature and extracting as many facts as we can. So we can use natural language processing software to extract those. We republish them in a semantic web format, right? This gives us little open factoids, which we call triples, because they have, basically a subject, a verb, and an object. We can go to more titles, and these are just the titles, get more facts. And because we're using standards, right, we're not just using legal standards, we're using technical standards, we get some automatic assembly of the facts into an open knowledge graph. We can go to databases, we can extract things out of data models, pathway databases, NCBI, Entree, and again, we can auto-transform and do this without disturbing any of the existing work. You didn't have to put your database onto the web, you just needed to use CGI bin. This is usable if you use standards and you have rights. And so if I'm making a point over and over again, it's that you need to use technical standards and you need to have the right to do it if you want to do this kind of reuse. And what you start to get is these big graphs of knowledge that smarter people than us are going to come along and use. And what we've seen in just 6 weeks of talking about this is the neuroinformaticists and the neurologists have come out of the woodwork demanding this because they want to use it. And they know what to do with it a lot better than we do. We don't know anything about neuroscience. We just chose it for a variety of strategic reasons and scientific reasons. But these people want to reuse it. They don't have the incentives to build it. They don't have the rights to go after it. And they don't have basically the attitude problem that we have to give it away. But this is a way to encourage other people to start to reuse things. And again, we can use copyright to do that. And once we make it easy and legal, people are going to use the tool. So, and this is going to get a little more relevant to Shree's life. I'm going to go into some synthetic biology stuff. So biological materials, right? We're going from copyrights now into patents and contracts. Copyrights are really simple compared to patents and contracts, unfortunately. So the way things go now, let's say that X is a scientist at MIT and Y is a scientist at Harvard. They both do synthetic biology and biological engineering. So they create papers, they create tools, they create reagents, they create data. Because it's synthetic biology, all of this stuff can actually go onto a wiki. Because the biobricks, the synthetic biology parts can be turned into A's, T's, C's, and G's and put onto the wiki. They can be transferred without any interference. But if they're not on the wiki, the sharing mechanisms are non-automated. They go through technology transfer offices. They're very lawyer-centric. They're slow. You'll get a 15-page materials transfer agreement in your inbox, which typically, I know that there's a scientist here who will remain nameless told me he just throws them away when he sees them. And he sends out the material, right? So that can cause problems. And so I'm going to tell a little story about what's called golden rice. This is a genetically modified version of rice. It was enhanced with vitamin A. Vitamin A deficiency is a major health problem in the developing world. And so that's regular rice on the left and golden rice on the right. Now the problem is a sharing problem. So this is the pathway that they basically enhanced beta-carotene in the rice through genetic engineering. Those all represent contracts and patents on different pieces of the project. And I actually didn't even have enough space because there are more than 70 intellectual property, intangible property agreements on that pathway. And I did not enhance or simplify the pathway. So this group of this consortium of universities that said, we would like to give away this rice that's enhanced with vitamin A to the developing world. We don't want to make any money on it. We'd like to give it away and let people grow it, make it, improve it, because it didn't actually work that well, which is the dirty secret of most GMO organisms right now. We'd like you to improve it and make it work the way we want it to work. It took 2 years of lawyering to figure out how to give it away because of the intersections of contracts. This is a very, very real problem. And there were only like 6 patents. The patents are the easy part. It's negotiating all of the contracts. Because in the contracts that go in, you say, well, I don't know what this is good for, but if you figure it out, I want 2%. Right? It's a really, really common, it's a pretty common problem. So what you can get after is actually taking the models of free software and the models of Creative Commons and saying, when I create something, when I create a reagent, when I create a biobrick, I want to make the permissions explicit and predetermined. Now, this is easier for software than it is for science in a lot of ways because these things are technically patentable. You might not have the right to do that. That's something that we're trying to figure out. What's the balance between you asserting rights as a scientist or your PI asserting rights at the lab level and what the university can do to come in and undo that later? And we're trying to figure out exactly where that tension goes. But the goal, again, is to say use standard technology, use standard contracts, make the sharing permissions explicit and predetermined, and start creating incentives to track the reuse of your work. So how would that look here? So here's the inverters and logic page from parts.mit.edu. These are a batch of standard parts, which I can use to build machines. Here's one of them. And I'm going to focus in on a little bit of it later. But what you can see is we see who designed it, who owns it, who owns the group. We see that there's a physical instantiation of it. It's in, we know exactly what well it's in the MIT distribution. We have all of this information about the physical stuff. We have this, which is basically if you have a DNA synthesis machine, lets you make it. Right? As Drew has shown me, he's got jars of A, T, C, and G kicking around the office. You can actually just make this stuff. It's functionally equivalent. So what would standard contracts for DNA look like? Well, we probably want to talk about things like liability. Who's liable if you use this to create a virus? Me, you, MIT. Who owns it? Do you own it as a scientist? Does MIT own it? If you make something out of 5 of these parts, who owns that part? Right, these are very open questions. How are you allowed to use it? Well, I give you the right to use it in all research. Well, what's research in a pharmaceutical context? One out of 1,000 compound makes it out of, preclinical. Is it research until you get to phase 3? Would I give you the rights to use it in energy research but not health? And who are you allowed to give it to? Right? Do you have the right, if I give it to you, do you have the right to give it to Austin? Does he have the right to give it to Sri? What if it gets into the Google cache? Because I can download and make it. What does it mean to make it actually is publicly searchable? Right? None of this stuff is really quite established yet. But if we actually did get it done, you could answer 3 simple questions to choose a license for your DNA. You could get metadata. You could start looking at the reuse of your part. Because it would be really cool. This is a composed part. Agreement in your inbox, which typically, I know that there's a scientist here who will remain nameless told me he just throws them away when he sees them. And he sends out the material. Right? So that can cause problems. And so I'm going to tell a little story about what's called golden rice. This is a genetically modified version of rice. It was enhanced with vitamin A. Vitamin A deficiency is a major health problem in the developing world. And so that's regular rice on the left and golden rice on the right. Now the problem is a sharing problem. So this is the pathway that they basically enhanced beta-carotene in the rice through genetic engineering. Those all represent contracts and patents on different pieces of the project. And I actually didn't even have enough space because there are more than 70 intellectual property, intangible property agreements on that pathway. And I did not enhance or simplify the pathway. So this group of this consortium of universities that said, we would like to give away this rice that's enhanced with vitamin A to the developing world. We don't want to make any money on it. We'd like to give it away and let people grow it, make it, improve it, because it didn't actually work that well, which is the dirty secret of most GMO organisms right now. We'd like you to improve it and make it work the way we want it to work. It took 2 years of lawyering to figure out how to give it away because of the intersections of contracts. This is a very, very real problem. And there were only like 6 patents. The patents are the easy part. It's negotiating all of the contracts. Because in the contracts that go in, you say, well, I don't know what this is good for, but if you figure it out, I want 2%. Right? It's a really, really common, it's a pretty common problem. So what you can get after is actually taking the models of free software and the models of Creative Commons and saying, when I create something, when I create a reagent, when I create a biobrick, I want to make the permissions explicit and predetermined. Now, this is easier for software than it is for science in a lot of ways because these things are technically patentable. You might not have the right to do that. That's something that we're trying to figure out. What's the balance between you asserting rights as a scientist or your PI asserting rights at the lab level and what the university can do to come in and undo that later? And we're trying to figure out exactly where that tension goes. But the goal, again, is to say, use standard technology, use standard contracts, make the sharing permissions explicit and predetermined, and start creating incentives to track the reuse of your work. So how would that look here? So here's the inverters and logic page from parts.mit.edu. These are a batch of standard parts, which I can use to build machines. Here's one of them. And I'm going to focus in on a little bit of it later. But what you can see is we see who designed it, who owns it, who owns the group. We see that there's a physical instantiation of it. It's in, we know exactly what well it's in the MIT distribution. Right, we have all of this information about the physical stuff. We have this, which is basically, if you have a DNA synthesis machine, lets you make it. Right? As Drew has shown me, he's got jars of A, T, C, and G kicking around the office. You can actually just make this stuff. It's functionally equivalent. So what would standard contracts for DNA look like? Well, we probably want to talk about things like liability. Who's liable if you use this to create a virus? Me, you, MIT. Who owns it? Do you own it as a scientist? Does MIT own it? If you make something out of 5 of these parts, who owns that part? Right, these are very open questions. How are you allowed to use it? Well, I give you the right to use it in all research. Well, what's research in a pharmaceutical context? One out of 1,000 compound makes it out of, preclinical. Is it research until you get to phase 3? Would I give you the rights to use it in energy research but not health? And who are you allowed to give it to? Right? Do you have the right, if I give it to you, do you have the right to give it to Austin? Does he have the right to give it to Sri? What if it gets into the Google cache? Because I can download and make it. What does it mean to make it actually is publicly searchable? Right? None of this stuff is really quite established yet. But if we actually did get it done, you could answer 3 simple questions to choose a license for your DNA. You could get metadata. You could start looking at the reuse of your part. Because it would be really cool. This is a composed part. If just like I could do this for remixed music, I could get a graph that said, show me all of the places that my biobrick has gone. Show me all the impact that my work has had. Again, because we know the owner and because we know the components, we can start to do that if we use these same technologies of standard contracts, standard technologies, and open tracking. So the conclusion, right, at which point you're free to quiz me, is I said at the beginning that I think innovation is directly related to the freedom to legally reuse and transform knowledge. And I think that the law and the technology can help us to do that, but only if we start to think about reuse all the time. How do I retain the rights to legally reuse and republish the information I create? How do I agitate for the right to transform and reuse the information others create? How do I make technically sure that the stuff that's legally open is findable and usable? Right? And just a brief digression, the White House complies with openness requirements by printing out emails and mailing those prints to the archives. So that's legally open, but you can't search them. So you need to make things technically available using standards, not just legally available. And you need to start thinking about scientific impact as a measure of reuse, not just your citation index. Because that's what's really going to change this. If the group of us are the only ones who care about this, then, well, that's cool. But if MIT starts saying, show me everything you've openly licensed, if the NIH starts saying, show me the reuse of the materials we gave you money to create, then everyone's going to come along. And that's how we're really going to change the system. So thank you again. I'm happy to take some questions, and it's been great being here.
John, thank you. Has there ever been anybody that says, look, I've got copyrighted material, but I want to translate it into your system? Why would they do that? And number 2, if they did, is there any way that the IRS would make a decision that says, yes, it's legal to claim this as a deduction when you donate to the open system?
So we've got a lot of folks who have copyrighted works that are putting them into the system. The danger in the sciences is that frequently you've given your copyrights away already. If you've published already, the odds are you've signed away the rights to use our licenses. And so there are various ways you can try to go back and reclaim those. But new works, yeah, those are easy to do, and certainly the Public Library of Science, Biomed Central, Springer Verlag has actually adopted our licenses for their open choice program. And there's a growing set of journals that are doing this, of authors that are doing it. We're talking to various sets of museums about putting back catalogs of journals online. We have looked into copyright donations as a tax deduction. But that's the kind of thing that I would recommend that you consult with your own accountant and lawyer on, because it all boils down to what's the value of your copyright. And that's not something that we can standardize on. So, and also, we're not a legal firm. We can't give legal advice. We just write contracts. There's all sorts of standard disclaimers. But that's something, if your copyrights have a net present value, then you can probably talk to your accountant about. No problem.
So if you could say a little bit more about the ways to accomplish and challenges to accomplishing embedding attributions and having the attributions stay as some scientific object goes through a chain of reuse?
That's a good question. So I showed the text mining network stuff. So figuring out provenance and attribution turns out to be the hardest technical piece that we've run into, which is how it's easy to extract who wrote the article, but how to attach that to the triple or the fact or the biobrick or the picture so that it carries along throughout. And that's hard from the first part. And what if you do something with it that I don't like? I might not want my name attached to it. The classic example here is I write an article on evolutionary biology. I put it under a Creative Commons attribution license. I let you make a derivative work. You come along and write a creationist article supporting your point of view by taking 3 of my comments out of context. Do I want attribution? Probably not. So I don't think we have the answer yet. If just like I could do this for remixed music, I could get a graph that said, show me all of the places that my biobrick has gone. Show me all the impact that my work has had. Again, because we know the owner and because we know the components, we can start to do that if we use these same technologies of standard contracts, standard technologies, and open tracking. So the conclusion, right, at which point you're free to quiz me, is I said at the beginning that I think innovation is directly related to the freedom to legally reuse and transform knowledge. And I think that the law and the technology can help us to do that, but only if we start to think about reuse all the time. How do I retain the rights to legally reuse and republish the information I create? How do I agitate for the right to transform and reuse the information others create? How do I make technically sure that the stuff that's legally open is findable and usable? Right? And just a brief digression, the White House complies with openness requirements by printing out emails and mailing those prints to the archives. So that's legally open, but you can't search them. So you need to make things technically available using standards, not just legally available. And you need to start thinking about scientific impact as a measure of reuse, not just your citation index. Because that's what's really going to change this. If the group of us are the only ones who care about this, then, well, that's cool. But if MIT starts saying, show me everything you've openly licensed, if the NIH starts saying, show me the reuse of the materials we gave you money to create, then everyone's going to come along. And that's how we're really going to change the system. So thank you again. I'm happy to take some questions, and it's been great being here.
John, thank you. Has there ever been anybody that says, look, I've got copyrighted material, but I want to translate it into your system? Why would they do that? And number 2, if they did, is there any way that the IRS would make a decision that says, yes, it's legal to claim this as a deduction when you donate to the open system?
So we've got a lot of folks who have copyrighted works that are putting them into the system. The danger in the sciences is that frequently you've given your copyrights away already. If you've published already, the odds are you've signed away the rights to use our licenses. And so there are various ways you can try to go back and reclaim those. But new works, yeah, those are easy to do, and certainly the Public Library of Science, Biomed Central, Springer Verlag has actually adopted our licenses for their open choice program. And there's a growing set of journals that are doing this, of authors that are doing it. We're talking to various sets of museums about putting back catalogs of journals online. We have looked into copyright donations as a tax deduction. But that's the kind of thing that I would recommend that you consult with your own accountant and lawyer on, because it all boils down to what's the value of your copyright. and that's not something that we can standardize on. So, and also we're not a legal firm, we can't give legal advice, we just write contracts. There's all sorts of standard disclaimers. But that's something, if your copyrights have a net present value, then you can probably talk to your accountant about. No problem.
So if you could say a little bit more about the ways to accomplish and challenges to accomplishing embedding attributions and having the attributions stay as some scientific object goes through a chain of reuse.
That's a good question. So I showed the text mining network stuff. So figuring out provenance and attribution turns out to be the hardest technical piece that we've run into, which is how it's easy to extract who wrote the article, but how to attach that to the triple or the fact or the biobrick or the picture so that it carries along throughout. And that's hard from the first part. And what if you do something with it that I don't like? I might not want my name attached to it. The classic example here is I write an article on evolutionary biology. I put it under a Creative Commons attribution license. I let you make a derivative work. You come along and write a creationist article supporting your point of view by taking 3 of my comments out of context. Do I want attribution? Probably not. So I don't think we have the answer yet. And I think there's probably not going to be a single answer. I think that we need to keep thinking in terms of Aikido. So if you look at something like watermarking for MP3s and for files, I think that watermarking for digital rights description and provenance as opposed to digital rights management and control is an interesting idea. I think that any of these technologies that are developed for control, if they're used in an inverse simply for description and for persistence of annotation and attribution, offer us some potential first passes. But we don't have the answers yet. This is really early days.
I was wondering if you could give us a little bit of scope, like how extensively is Creative Commons currently being used? How many things do you have Creative Commons licenses on them, and how many people, institutions?
So there's, as of about 4 weeks ago, we're at 55 million objects licensed on the web under our licenses. That's according to Google and Yahoo, which are the 2 big engines that index our work. I would say that probably the significant majority of those are blog pages. And so that skews the count, because if you think about it, every blog page has its individual trackback page. Each of those shows up as a distinct object. So I think that really skews and messes with the numbers. I think it's probably, if you treat each blog as an object, it's probably more down in the 10 to 15 million range. But if you look at things like Flickr, Flickr.com is there's a little sticker on my computer. It's a photo sharing site. It's a default option on Flickr to make your photos open and public. And that's as we've seen ourselves embedded into those tools, we've seen what we've been doing spike. There are some things that are going to happen in the next 6 to 12 weeks that are going to make it much easier to author Creative Commons tools and standard applications. That's where we've really had to go. But treat it like a startup. We got enough buy-in that the big content creators and managers have started talking to us about how to go forward. We've also got things like there's a remix contest that just launched a couple of days ago. It's not a band I know anything about, but it's a side project of Linkin Park, right? We're getting a song every 5 minutes uploaded into the remix system under a Creative Commons license. So I mean, these are the ways that you can really start to dramatically increase the content that comes up and onto the web under our licenses. In terms of science, the dominant open access journals, in a political or cultural sense, all use our licenses. Springer, which is the world's largest commercial publisher, lets you buy the right to use one of our licenses. We're starting to see more and more journals standardize around either our open license or the GNU Free Documentation license, which gives a lot of the same essential freedoms. We've seen wikis like OpenWetWare adopt our licenses. We've seen a lot of other wikis adopt the licenses. We're negotiating with Wikipedia to make our licenses interoperate with their licenses, that kind of thing. We weren't around when Wikipedia started, and so we're trying to figure out legally how do you make the license they started with, which is viral, interoperate with one of ours so that we can mix and match content. So we've seen a lot of uptake on the culture side. You know, and Science Commons is just getting ready to launch its own licenses and things like materials transfer and in some of this metadata work, and we'll see what kind of uptake we get over the next 6 months.
interesting statement that GPL is responsible for the open source and free software movement. But some people argue that really that was just a direct result of economics. That once the web was around, it was easy enough for me to coordinate with other people to write software, then it was in some sense inevitable that this would happen. So can you comment on that?
I'm actually gonna, I see Randy commenting. Randy was there.
Yeah, so the thing to remember is that when the web happened, the business's view was that the internet would not be successful. And the internet would not be successful because there was no way to make money on it. And so the common wisdom at the time was actually that the entire free software effort was going to fail because nobody would make any money on it. I'd say that the success of it, was obviously not obvious at the time. Perhaps it was a natural force, in which case it was an important natural force to discover. And I think they get credit for it. They can patent the natural force.
And Randy was, I think, you were at Apple
I was at Apple
during that point?
In the early 90s doing the internet stuff at Apple. And that began before that during the internet stuff. But it was crystal clear, even at Sun Microsystems, where the network is the computer, the view was that there was no way to make money on the internet. And therefore it was for researchers or something like that.
Yeah, but so my question was slightly different, right? It was saying, I mean, regardless of what people thought about the economics at the time, the true economics of the situation was that it was inevitable that people would be able to do it once they had the means, namely communicating.
Well, I'm not sure, again, in the absence of the legal right to do that, I'm not sure Apache, and Tomcat have all of the materials around them. I know Apache's got its own license. BSD's got its own license. But I think that the viral license around Emacs and the C compiler, right, these two really useful tools, created an entirely free platform. And it's instructive to go back and read some of the decisions that were made legally and technically. And I think that Richard and the Free Software Foundation made some legal decisions that really enabled all this to happen. They made some technical decisions that opened things up for Linux, especially in terms of kernels. But I think it's almost impossible to understate the importance of the GPL. Because software started getting asserted with copyrights and started being locked up with copyrights. And the idea that you could flip copyright to help yourself is something that's really, that's why Creative Commons is here. That's why free software exists. You wouldn't have it without the GPL. And I think that it's, it's something that you have to give credit where credit is due. And, Tim Berners-Lee didn't put the web under GPL. He just gave it away. He made it public domain, right? So I think that's a lot of where that argument comes from. But when you sit and you talk to Tim, he'll tell you, well, I didn't patent it, I didn't GPL it. What I think was most important is that I'd let you view source. I let you copy the HTML and edit the contents of it and put up your own web page. He thinks it's a technical choice as much as anything when you sit and talk to him. So I don't think there's one answer, but I think you got to give credit where credit's due, and the GPL changed software licensing forever.
My question is about academic research and whether to patent or not patent something. And so I've been to a lot of presentations given by offices of technology and licensing of universities. And they kind of threaten academic researchers to patent their stuff, because if they don't, the threat was if we didn't patent our stuff, then a pharmaceutical company wouldn't invest the $500 million needed to take that to help humankind. And so the threat was, don't just sit in your ivory tower. If you really want to make an impact on the world, you need to patent. And so, go to offices of licensing technology. And of course, academic researchers are too lazy to do it because it's all legalese and it takes years and months or whatever. But I mean, I guess my question is, is this system making it easier for academic scientists to do what is, I guess, maybe the right thing to both share, but also make sure that the thing is exclusive enough to have the pharmaceutical companies invest in it in the long term. That was the threat that was used against.
Right. Well, there's a couple of reasons for that. One is that, I mean, again, there's this legislative mandate to commercialize, and I think there's also an unrealistic conception of the value of a single piece of the discovery puzzle. And when you patent smaller and smaller pieces of the pie, right, it gets harder and harder to assemble those into something that's fundamentally useful. So I think it's up to the scientists to decide whether or not this is valuable enough that it needs to be patented and invested in. Yeah, I don't think that that's something that Science Commons can decide. I don't think it's something that the OTL can decide.
I mean, what does the MIT Office of Licensing Technology think of?
We've actually, they hosted the first meeting that we put on last year. Lita Nelson it has been very good to us from the beginning. You know, MIT hosted the Free Software Foundation and still does. OpenCourseWare, DSpace, MIT is pretty forward-looking in that. And I think it's up to the scientists to be informed clients of the technology transfer offices. I mean, these are good people doing good work, but I mean, they don't know that any more than I do the actual utility of a given gene or a given protein. It's your job to figure out how valuable it is and decide what to do with it. And I think that the choice needs to go to the PI. Yeah, but I think that you should have the right, if you want to open source your stuff, to do so. If you want to create GPL software, you should have that right. If you'd like to give away your genetic works, you should have that right. If you really come up with something truly novel and valuable that you think needs a monopoly right to encourage investment, you should have the right to do that too. But you should have guidelines that help you make that decision. You should have some best practices for how to deal with those decisions as you make them. And right now, scientists don't have a vocabulary for that. They're not part of that decision because all you do is get a 15 to 50-page contract that you have to figure out. And so what we try to do is to play a translation role. You know, we try to make it easier for you to understand what your choices are, what the implications of those choices are, and what options you have within each choice once you make it. And what I keep coming back to is that whether or not you patent ought to be a decision that you make as a scientist with your university and with your technology licensing office. But you ought to give a huge exemption for research that basically allows anyone to do blue sky work with whatever you've got without coming to you for a license. You should not negotiate for things like, you know, if you look at the numbers in the pharma business, right, it's, you know, 1 in 1,000 targets becomes a hit with a lead. You know, 1 in 1,000 leads goes into the mouse, 1 in 1,000 of them make it into the clinic. That's a lot of negotiations for things that are never going to make it to the market. And I think expanding those research definitions so that you only negotiate the transactions that are likely to lead to money, you know, makes a lot of sense. I think expanding the research definitions so that everyone here knows exactly what their rights are, you know, those are the kind of things that we can do to help out. But a standard contract is never going to help you when you have a compound. You're never going to use one. You know, but you can license that compound in a socially responsible way. You can license the patent in a socially responsible way. And that's where we can help. I see. I'm going to come to you. Right. All right.
Yeah, so you mentioned how MIT is pretty amenable to this, or seems like the CLO here is, I mean, do you expect resistance at the university level from most places, or how do you plan on getting around that?
Well, I mean, I have no idea what's going to happen when we actually start putting out contracts and asking people to use them, but we haven't gotten a lot of resistance. Everyone just says, yeah, it's going to be really hard. Good luck. But no one says, you know, that's immoral or stupid or wrong. They just that's going to be really hard, you know, and you know, we wish you the best of luck. But when you walk in and say, I want to take lawyers out of the equation, it's remarkable how friendly the reception is.
John, is there an implied threat in this system that's going to make it easier to adopt? If I have copyrighted software, or if I'm tempted to patent it on the conventional system, do I have to worry about somebody just taking it anyway and using this system in secret to maximize their own benefit, and then I've got nothing because I've got this nice pretty patent that nobody can afford? It's not out in open source where I can watch enthusiastic amateurs just raise holy hell with it and come up with 50 better things than I imagine. Is there an implied threat that actually works to everybody's benefit here?
I don't know yet. I think that this is the hard thing with the patents is that unlike copyrights, you have to spend so much money to get one that people really like to protect them. And there are things about patents that are not bad because if you patent something, you have to publish it. There's an implied disclosure, there's a direct disclosure in the patent office that doesn't really necessarily apply in copyrights. And I guess I've not thought about it in terms of implied threats. I've thought about it in terms of incentives, which is, most of the scientists I know are motivated, especially the ones that are at places like MIT or in the academic world, are not motivated by dollars. They're motivated by the idea that they're going to change the world in some significant way, that they're going to rewrite some piece of the dogma of their field. And by creating ways that make it easier to do that make it easier to track different ways of doing it. I mean, I've met scientists who don't like to write papers but are just magnificent data generators. There's no way to reward those people right now. There are people that are magnificent, under the hood, right? The only metric for that is citations. And so by creating ways that you can track that by saying, well, I didn't get any papers out last year, but I made 5 antibodies that are all over the place generating other papers. And having that be an easy tracking thing, to me, was an implied incentive for the people that are good. I guess it's an implied threat if what you do is kick out Me Too papers that don't add really new information to the system. I mean, I guess that's who it really would threaten, is someone who publishes the 3rd paper in every year but has the big enough name to get into Nature. And that's probably who this threatens most. I think if you've got a patent, you've got a patent and it's been published and someone can violate it and you can try to sue them or not.
Thank you. Okay. Is there any idea that there'll be a university or a consortium that they'll be the first out of the box to say to their researchers, we're going to go with the John system, and his system has priority and everything else is second runner, and then you'll hear this sucking sound coming out of the lesser mortals who are losing their best and their brightest to this type of setup?
That would be nice. I certainly, we hope that the major research universities see the benefit of this in terms of offering options to faculty as a way of attracting faculty. We certainly hope that's going to be the case, but I can't. I mean, we're talking to some of them mainly in the context of publishing. I think patents are going to come second after we get through publishing, and we hope to have some announcements, in the fall. But it's slow. Universities are change-resistant institutions, so but we're hopeful. I think I saw. Okay.
In view of the importance of the computer-readable licensing information, how does this fit in with public domain information? I was frustrated one time that there didn't seem to be a standard way to encode that it worked as public domain in a Creative Commons consistent manner. Is that where I'm just mistaken on that point?
No, you're not mistaken. We actually built a public domain dedication at Creative Commons, and no one used it. We turned it off. And the easiest way to declare something that's in the public domain is to basically write it at the bottom of your web page.
It doesn't,
right.
The computer readable side I'm interested in.
Right. There's the hard part is that when we actually did the legal part about declaring something public domain, it's much harder to waive your copyright entirely than selectively. And so, don't ask me. We actually had to go through like a 5-step process for you to put something into the public domain, and we'd have to send you emails saying, "Are you sure? You should call a lawyer." Whereas if you just want to license it openly, we can do that in 1 step. So, the law is the law, and the law has grown like coral over the last 200 years, and it doesn't make sense to anyone but lawyers in a lot of cases, and this is one of them. So, I mean, it depends on what you want to be in the public domain, I guess. Google, the nice thing about Google is Google doesn't care. Google searches everything anyway. And I think that's probably where this is all going to go. And it's, you should be able to search anything. It's whether or not you have the right to reuse that's not. And it's very hard to label something as being in the public domain unless you put it there, right? You have to have the right to assign the right and to assign the metadata. If the metadata is describing a contractual relationship that you have with the work, I can't put it on something you created.
So what happens in future when you start writing things in other languages like OWL, where you can infer knowledge? So RDF allows you to mark up the knowledge, but what happens with the other technologies upstream when the semantic cake that comes along? Starts with all this knowledge create more knowledge, where does the copyright, the patent law, where do we go there?
We don't know. I mean, when it comes to facts of nature, it's kind of hard to argue that writing software that generates new facts and associations is creative expression. I mean, that would be my argument. Because the copyright protects the expression, not the idea, right? So the way you say it, not what you say. Whether or not that generates patents is a very interesting question, and I would hope that it wouldn't, but I wouldn't be surprised if it did. But that's all the kind of stuff that the courts decide. The one thing that you really learn is that the courts are the compiler. The courts are where you find out how this stuff really works, and until then, it's all theory. So I think Shree's got us done.
Thanks, John, once again.